Morning, everyone. This is Lisa Lieben with IRMA. We'd like to welcome everyone to our 2020 Virtual Education Summit. Today, we are having our legal update, which will be presented by Margot Ely, Executive Director of IRMA. Before we get started, we have a couple of housekeeping items. For all of you that are familiar with Zoom, at any time during the presentation, if you have any questions, please use the question and answer box down in the lower panel of your screen, and we will be reading them off during the presentation so that we can answer them. If at any point we need to hold off on questions till the end, we will do so, depending on how many we get at a time. Also, at the end of this webinar, there will be a survey asking you to please fill that out so that we can see what you felt of our presentation today and what other topics we can offer. And with that, I'm going to turn it over to Margot Ely.
Good morning, everyone, and welcome to IRMA's 7th Annual Education Summit that we have themed We're Better Together. So during the month of October, for 3 weeks, we are going to have webinars every Tuesday and Thursday morning from 9:30 to 11. And the topics I think are really great. So on Thursday of this week, we are going to have a presentation on how to conduct internal investigations. At each of these webinars, you're going to hear from fellow IRMA members and experts on topics that are relevant for IRMA members. You know, next week we have one talking about workers' comp, surveillance, employment, and fraud. And I just have to tell you that we have had a lot of success doing surveillance during COVID. It's amazing how many injured workers cannot work at all, not even sedentary duty, but what we find them doing at home shows that they could definitely be working. So for today's presentation, I looked at what has changed in the law and important cases that have come down over the last year in Illinois and in our 7th Circuit, which is the federal circuit that we're in. And so without further ado, let's just get right into it. The most important case that was just decided this month is an Illinois Supreme Court case that overrules prior case law and makes workers' comp injuries even more likely to be found compensable. So this is a case that was filed by a sous chef who injured his knee when he was in the walk-in cooler trying to find a pan of carrots that his coworker lost. And when he was kneeling on both knees and when he got up, he heard a pop and felt a pop in his knee. So, you know, the way that we would, prior to this Illinois Supreme Court decision, the way that we would analyze that claim is, well, was he at any greater risk than the general public? He was just kneeling and got up, and he could have been doing that at home as well. And even at the trial in this case, he testified that, yeah, the movement that he made was no different than if he was bending down to get something from under the bed at home. And so the arbitrator in this case found that his injury was compensable, but the Workers' Comp Commission reversed, and then it went to the circuit court reversed, then it went to the appellate court, and the appellate court also said this is not compensable. So the arbitrator said it's compensable. The Workers' Comp Commission said nope, it was just a neutral risk and he was not at any greater risk, so it's not compensable. Circuit court agreed with the commission. Appellate court agreed with the circuit court, finding that the risk posed to the employee from the act of standing from a kneeling position while looking for something was not distinctly related to his employment. Then it gets to the Illinois Supreme Court, and the Illinois Supreme Court reversed the commission, the circuit court, and the appellate court, and found that, you know what, we don't really think that an employee needs to show that they're at any greater risk than the general public. As long as it's something that, you know, is sort of related to what they're doing for their job, then it's going to be compensable. And so the new test now is whether the injury arises out of the employment when they're just doing a common bodily movement, right? Reaching, bending, kneeling, even just walking. That if they're injured while they're doing just this regular activity, that they don't have the burden to prove that they are at any greater risk than the general public. So all those cases where we have said, oh, you know what, they're just reaching, there wasn't any, they weren't wearing any equipment that made the reaching more difficult. That's no longer the analysis. This Illinois Supreme Court decision now overrules a whole lot of prior cases saying that you need to show that you're at a greater risk than the general public. That's no longer the case. So we'll be working closely with our members as these types of cases come in to analyze whether it's compensable or not under this new case law precedent that the Illinois Supreme Court decided. So moving on then, this also is an interesting decision. So we know that from a Champaign case, a case that came out of Champaign a couple years ago, when city council members were texting each other during a city council meeting, that those text messages, even though they were on personal devices, that those text messages were subject to FOIA. And that decision relied a lot on the fact that there was a city council meeting going on at the time. So those text messages were deliberative, right? They were elected officials deliberating over public business. Well, this new case now goes further. And what it found is that whether or not there's a meeting going on at the time, that personal emails or personal text messages or any kind of communication about public business that's on a personal device are in fact subject to FOIA. And so a quote from the case I've included here because it kind of shows how expansive this could potentially be. It refers to a department head, right? So if a department head can deprive the citizens of the right to know what his department is up to by the simple expedient of maintaining his department emails on an account in another domain, that person, and that is, I mean, that purpose, the right to be informed, is hardly served. So what this case finds is that any of us who work for government, if we are texting or emailing about public business, that those communications are subject to FOIA. What the court held is that whether or not a record is a public record under FOIA is the first prong is the record must pertain to public business rather than private affairs, right? We know that. And then the second prong is that the record must have been either prepared by a public body, prepared for a public body, used by a public body, received by a public body, possessed by a public body, or controlled by a public body. So all of us, and especially our elected officials, should be cognizant of using personal devices to discuss public business because that communication will be subject to FOIA. So the question is, well, how do you enforce it? If you get a FOIA, do you tell your elected officials they need to bring their phone in for you to search it? And the court held that all that you have to do is have those officials sign an affidavit, legally admissible affidavit, that there were no responsive communications on their personal device. And the court also suggests that, officials can just avoid any personal account disclosure by just refraining from using personal accounts to conduct business. So, I mean, that may not be viable, but it's something that perhaps your elected officials and even yourselves with your employees should consider saying, we don't want communications about public business to be on personal devices. And then you avoid those tough situations where you're asking your elected officials to share information on a personal account. Here's an interesting case too. So this is the Seventh Circuit. So you all know that the Seventh Circuit Court of Appeals is just below the United States Supreme Court. So in Illinois, and for all of our IRMA members, when you have a federal case, it's always in the Northern District of Illinois. When it gets appealed from the Northern District, which is the trial court, it goes up to the Seventh Circuit. And so Seventh Circuit judges are appointed for life, just like Supreme Court judges. And this case came to the Seventh Circuit It arose out of a situation where a police officer was working with other police officers, and there was a discussion. And this one police officer said, "Hey, if you call me a liar again, we're going to take it outside." And the chief decided, you know what, I don't really like that statement. It makes me worried about whether he's mentally stable or he's violent. The statement itself violated the violence policy, violence in the workplace policy. And so the chief put that police officer on administrative leave and ordered him to undergo a fitness for duty evaluation. Now, this particular officer had served in the US military previously, and he had previously been diagnosed with PTSD. And so he did have a fitness for duty exam, and he was brought back to work. He was found to be fit at the fitness for duty, but he filed a case under the Americans with Disabilities Act, and he claimed that sending him for the fitness for duty was discriminatory. And he also claimed that the fact that he did not get paid any overtime or premium pay during his administrative leave was adverse employment action. So we know that anytime somebody files an employment case, they need to show that there was discrimination and that they suffered adverse employment action. So we know a termination is adverse employment action. If you're fired from your position, that's adverse employment action. So is a demotion is adverse employment action. But in this case, the court found that when overtime pay or premium pay is a significant and expected part of an employee's annual earnings, that the denial of that pay may constitute adverse employment action. So when you have somebody on administrative leave, it's just an additional thing to kind of think about when you're paying them. Wow, because they're always on paid administrative leave when you're ordering them to undergo a fitness for duty exam. The more interesting part of this case is the fact that he claimed that he was sent for the fitness for duty exam because of his prior PTSD diagnosis. And it was really discriminatory because the chief thought that because he already had PTSD that he was more likely to be mentally unstable. And what the court found, and I just had some really good quotes, I think, from this Seventh Circuit opinion, that, you know what, sending somebody for a fitness for duty exam when you have a reasonable basis for doing so is not at all a violation of the Americans with Disabilities Act. So, and this case really focused on the fact that police officers who are responsible for public safety, that the department has compelling interest to make sure that police officers are both physically and mentally fit to perform their duties. So, I certainly talk to a lot of IRMA members when they have concerns about an employee's fitness. This case is a very, very strong opinion that sending police officers for fitness for duty is absolutely legal, not only legal, but it's the responsible thing to do. Here's a couple of other quotes from that case. In any case where a police department reasonably perceives an officer to be even mildly paranoid, hostile, or oppositional, a fitness for duty exam is job related and consistent with business necessity. That is just really strong language showing that police departments, if you have a concern, then you need to act on it. And you can require employees, police officers who you have questions about their mental stability to undergo a fitness for duty exam. This year we've also seen an uptick in our First Amendment free speech employment cases. And so, as government employees, we have constitutional rights in employment. That's not true if you work for a private business. Since we work for government entities, we also have constitutional rights. And one that we've seen come up more in the last year than in prior years is free speech employment cases. And so the employees claim that they were terminated because of what they were talking about at work, and that they were engaged in free speech at work. And so they file these First Amendment cases. So in these cases, to prevail, the plaintiff has to show that he spoke as a citizen on a matter of public concern. So there's two issues there. Is the employee speaking as a citizen, or are they speaking as an employee? If they're speaking as an employee, then it's not First Amendment. If they're speaking as a citizen, then it is. And then the question of what is a matter of public concern? So when employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes. And the Constitution does not insulate their communications from employer discipline. What's really interesting is this Salmani versus Bartlett case, which was just decided a couple of weeks ago, which was a First Amendment retaliation case. And it found that a police officer's internal reports of fellow officers' misconduct do not qualify as a citizen. So when you have a police officer, for example, who claims that another police officer engaged in excessive force on a particular call, that may sound like a matter of public concern, right? I mean, in this day and age, everybody's talking about police use of force and things like that. But the truth is, based on these decisions, that's not free speech that's protected under the First Amendment. There was another case decided by the Illinois Appellate Court that went the opposite way, but it didn't involve a police officer. And so this other case, Adams versus Board of Education of the school district in Harvey, the superintendent decided that she thought that it was important to have an audit of school finances. And the board members, the elected board members, were not happy about that. In fact, one of them said to her, "You're really itching for an ass kicking." Thereafter, she reported that statement to the police because she felt threatened by that statement. And thereafter, the board members stopped talking to her. They sort of isolated her. They told her that her contract would not be renewed the following year. And she ended up not being terminated, but she went on leave before that contract expired. She went on leave because of the stress that it caused her. And then she sued for a First Amendment violation. And it went to a jury trial, and the jury awarded her $400,000 in damages. Well, the school district appealed that decision to the Seventh Circuit. And in this case, the Seventh Circuit found that her speech was protected because it was a legitimate subject of public concern. And what they found is that, you know what, if elected officials are threatening violence, right, then the public has a concern about whether that institution is functioning well or if it's working properly. And they said this was a matter of free speech. It was a matter of public concern. And as a result, they upheld the verdict. And that was another unanimous decision. Speaking a little bit about First Amendment and employment issues, this case is just a reminder that you can't be fired because of your political affiliation. So this case actually came from a newly elected county official who was a county clerk, and all of the deputy county clerks had supported the incumbent. Oops. So lesson number one, if you're a public employee, you should probably stay out of politics, because if the other guy wins, then the new guy might not like you, right? And so we all know that we should stay away from politics. But in this case, these deputy clerks had supported the guy who lost. So the new guy comes in, and guess what he does? He fires all the deputy clerks. And he claimed that he fired them because they weren't loyal to him and they had not supported him. And what this case holds is that depending on the position, you cannot fire somebody for their political affiliation. And in fact, the holding was the deputy clerks were protected from political retaliation, but that there are positions, and all of our managers who are on this webinar know that a manager position can be terminated for political reasons. But pretty much the rest of the jobs at any municipality should be protected from a political firing. What the courts will look at is job descriptions, your local code and ordinances, and sometimes statutes will also talk about what the functions are. And if the functions have to deal with, policy making, then you're more likely to be fired for political reasons if you're at a high level of policy making than if you're at lower levels, which are supposed to be more professional and less affected by political ramifications. So we talk a lot about the importance of job descriptions. This Seventh Circuit case emphasizes how important it is to have essential functions very specifically delineated in job descriptions. So this was an employee of Federal Express who had a shoulder injury, and after all of her treatment, she ended up with some permanent restrictions. The job description itself said that you had to be able to lift up to 75 pounds, but the job description didn't specify whether you had to lift 75 pounds up to your waist or above your head or up to your shoulder. And so the litigation involved a lot of factual questions about, well, what exactly is the essential function? Do you have to lift up to 75 all the time or infrequently? And there was testimony from employees saying, you don't ever have to lift 75 pounds above your shoulders. Nobody would do that. And then there was other testimony saying, oh yeah, you do have to do that. So part of the question was, well, wait a minute, who has the burden to prove what the essential job functions are? So we know that in employment cases, it's the plaintiff who has the burden of proof. And this case, it was interesting because the district court, the lower court, found that the plaintiff did not prove that the essential function was not what the job description said. So the job description said you have to lift up to 75 pounds. And even though she had testified that that's not always true, she failed to prove that the essential job function was less than 75 pounds. And so she failed to prove that she'd been discriminated against because she admitted she couldn't lift up to 75 pounds. So the majority found that the plaintiff failed to meet that burden of proof. But there was a dissent in this case. And the dissent talked about how there's currently a split in the federal circuits on the question of who should have the burden to prove essential job functions. And so what the dissent highlighted is that the majority of circuits have shifted the burden of proving essential job functions to the employer. And the Seventh Circuit did not. The Seventh Circuit stuck with the burden being on the plaintiff to prove the essential job functions. So I expect that this question may get to the Supreme Court, because anytime you have a split in the circuits on an issue, it's ripe for United States Supreme Court consideration. So perhaps in the next couple of years, we'll see that issue go to the Supreme Court. But, the point for IRMA members is to just remember that you are in charge of deciding what the essential job functions are, and the best place to be very specific about that is in the job description. To avoid factual disputes, you end up in litigation over a question of whether you needed to accommodate somebody's restrictions. So a review of your job descriptions and the essential functions is an important, although not very exciting probably, thing to do. There was one incidental holding in this case as well, and that is that the incidental holding, which reaffirms prior holdings, which is that, there's in ADA cases, there's always this question of, well, what is a reasonable accommodation, which involves that whole interactive process and talking to, the treating doctor, what kind of accommodation can we provide? but this case reaffirms that you do not ever have to provide a second employee to assist when the work required exceeds the employee's capability. So like in this case, she argued that, all right, I might not be able to lift 75 pounds, but if somebody else came over and helped me, then it could be accommodated, the fact that I can't lift the 75 pounds. Why don't you just give me a little helper once in a while when I have to do it? And the Seventh Circuit said, nope, that is not a reasonable accommodation, and you don't have to offer up a second employee to assist. So moving on to, so it's there was a lot of ADA cases in this last year by the Seventh Circuit. And so this, there's a couple of cases on obesity in the Americans with Disabilities Act. And so in the first case, which was Richardson versus the CTA, this case evolved from a bus driver. And the bus driver, he weighed 350 pounds in 2005, and by 2009, he was up to 566 pounds. He also had hypertension and sleep apnea, and after he had a medical exam, the doctor said, you know what? He has uncontrolled hypertension, and he can't work until his blood pressure gets under control. So he went on disability, and you know, the purpose of the disability leave was hopefully for him to lose weight. And so after 2 years on disability leave, the employer, the CTA, asked the employee, hey, can you give us some medical documentation to extend your disability beyond these 2 years? And he didn't give them anything. So they terminated him because he didn't give them anything. And he filed a lawsuit under the Americans with Disabilities Act saying that the employer, the CTA, discriminated against him because of his obesity. And what the Seventh Circuit found is that obesity alone is not a disability under the ADA. That obesity, in order to be covered by the ADA, that you have to have evidence that the obesity is caused by an underlying physiological disorder or condition. So this was an issue of first impression in the Seventh Circuit, and the Seventh Circuit followed the Second Circuit, the Sixth Circuit, and the Eighth Circuit. So now we've got 4 circuits that have concluded that under the ADA, obesity is only a disability if it results from an underlying physiological disorder or condition, and the plaintiff in this case did not make that argument. The next case is another interesting one for ADA and obesity, and that's Shell versus BNSF. So this case involves the question of the ADA prong, where you get protected if you're regarded as having a disability rather than actually having a disability. So the ADA says if you have a disability and a disability is a medical condition that substantially impairs a major life activity. So if you have a disability and your employer should have accommodated it, provided you a reasonable accommodation, you can sue when they don't do that. But there's this other prong, which is the regarded as provision. So we've seen more of these, and this allows employees who don't actually have a disability to sue saying, I didn't have a disability, but you, the employer, perceived me as having a disability. Some of these cases will come out of situations where an employee is needs an accommodation, like a scheduling change because they need to take care of an ailing parent. Perhaps they need Fridays off to take a sick parent to the doctor or something like that. So the employee himself doesn't have any medical condition, but sometimes those lawsuits are filed because they were regarded as, because they were taking care of an ailing parent. But the case that we're talking about here was a applicant for a position at BNSF, and it was a safety sensitive position because it worked on and around heavy equipment. So this applicant applied for this safety sensitive position, And the applicant was 5'10" and weighed 331 pounds, which equated to a BMI of 47.5. But BNSF had a requirement that for a safety sensitive position, the employee's BMI cannot be greater than 40. Because if your BMI is greater than 40, then you're at a substantially higher risk of developing other conditions such as sleep apnea, diabetes, heart disease, and BNSF found that these conditions can result in sudden incapacitation. Sorry about that. Sudden incapacitation. They could lose consciousness. And it's in order to be in a safety sensitive position, we're not willing to take that risk. And based on this guy's BMI, it was too risky to put him into this job. They told him that if he lost 10% of his body weight, he could reapply. But instead of doing that, he sued. He sued BNSF for discrimination under the Americans with Disabilities Act and said that they perceived him to be disabled. So this got to the Seventh Circuit, and the Seventh Circuit referred to that prior Richardson decision in its opinion and said, hey, obesity is not a disability. And the court went further and said that, you know what, the fact that the employer viewed him as being at risk of perhaps becoming disabled is not actually covered by the Americans with Disabilities Act. And so the Seventh Circuit in this case joined with the Eighth Circuit and found that the ADA does not prohibit discrimination based on a perception that a physical characteristic, as opposed to a physical impairment, may eventually lead to a physical impairment as defined under the Act. So the Ninth Circuit and the 10th Circuit also agree with that. So similar to Richardson, we have 4 circuits now that are saying, you know what, somebody who has a condition right now that increases the risk of them being disabled or having a disability in the future, that's not prohibited under the ADA. So this is, again, an issue of first impression in the Seventh Circuit. And the finding is, you know, an employer finding is what it is. So the value of performance reviews. I think everybody understands how important it is to be honest, direct, and accurate when you're doing performance evaluations of your employees. And the importance of performance evaluations cannot be overstated when it comes to employment cases. So in this case, this was a plaintiff who worked for this insurance company who had a work-related back injury. And she was treated for it, and she returned after her back injury. And when she returned, she was having performance issues. Now, even before she had the injury, she had performance issues. And so even prior to her injury, her performance evaluations identified her absenteeism, her lack of understanding of large product insurance products, large group insurance products, and the failure to be able to follow directions, apparently. And so when she got back from her injury, her performance continued to be a concern, and she was ultimately terminated. So she filed a case under the Americans with Disabilities Act and said that she was being discriminated against because of her back injury. And what the Seventh Circuit, and so summary judgment was granted for the employer at the lower court, in big part because the evidence showed that these performance concerns predated her injury and predated her condition, and that they were unrelated to her back injury. So what the court said is that the plaintiff has the burden to prove that the reason for the termination was pretext, and that it was really discrimination against her because of her back injury, and that she failed to show that the reason for her termination was because of her back injury. It was really because of her performance. And what the court said was, the ADA does not protect persons who have erratic, unexplained absences, even when those absences are a result of a disability. The fact is that in most cases, attendance is a basic requirement of most jobs. And so the plaintiff lost that case. One other argument she made is that she argued that they didn't accommodate her disability, but the problem was she never actually requested an accommodation. And so the court also said, you know what, you cannot file a case for failure to accommodate when you didn't even ask for an accommodation. So the employer won in this case as well. I'm thinking that everybody's heard about this case. This is another Illinois Supreme Court case that is significant, since many collective bargaining agreements, especially in police departments, collective bargaining agreements have a provision that says that disciplinary records should be destroyed every 2 years, 3 years, maybe 5 years, but unions have for many years negotiated these provisions in their collective bargaining agreements, requiring that disciplinary records are destroyed after a period of years. So it kind of gives police officers a clean slate, right? If you get in trouble in year 2010, then should that troubled record follow you when you apply for a promotion in 2015 if everything was good during that time? That's why unions want those disciplinary records destructed from personnel records. And so this case evolved from the city of Chicago, and the FOP filed a grievance because the city of Chicago was not destroying disciplinary records. And this case was litigated during the years that Laquan McDonald occurred, and the DOJ was in the Chicago Police Department and investigating, and came out with that big report. And so the arbitrator in this case said, yep, city of Chicago, the collective bargaining agreement says you got to destroy these records, so you better destroy these records. And so the arbitrator ruled against the city of Chicago. So you know that when you take an issue, when an issue goes to an arbitrator, the only way that you get to change the arbitrator's decision in court is if you can show that the arbitrator's decision is against public policy. That's really the only way to get an arbitrator's decision overruled, because the arbitration system is really supposed to just be attributable where you're looking at the language of a collective bargaining agreement, and the arbitrator is just interpreting the language of the collective bargaining agreement. So the court's role is, all right, is there something here that the arbitrator did that's void against public policy? And in this case, the Illinois Supreme Court said, you know what? A provision in a collective bargaining agreement that requires disciplinary records to be destroyed is void against the public policy of Illinois, and it's the wrong thing to do, and you can't do it. The Illinois Supreme Court cited to various provisions in the Local Records Act that require municipalities to only destroy records when the state archivist gives you permission to do so. And so the Illinois Supreme Court said destroying public records is against public policy, and this provision in the collective bargaining agreement is thrown out.
Margot, we do have a question. Do you recommend including attendance requirements in job descriptions?
Yes, I do. And so I think that to be on the safe side, your job description should say consistent attendance is expected and is an essential job function. All right, Lisa, thanks. If anybody else has any questions, I'm liking interruptions here and there, so give me some questions as we go through this information. Otherwise, I might end up a little quicker, and then Jenny's gonna get mad at me because I didn't take the full 90 minutes. Just kidding. Everybody probably has other things they could do if we get through all this. All right, so that's the the City of Chicago versus FOP. So go back through your collective bargaining agreements, make sure that you're negotiating something different. And so that, and make sure you're not destroying disciplinary records. You can't be doing that. All right, this is a case, a PSEBA case. And so, PSEBA is the Public Safety Employee Benefits Act. And we all know that in those career-ending police and fire injuries, and the career-ending police and fire injuries, that when they apply for a disability pension, that the real costs of the disability pension is in the PSEBA benefits. So depending on the age of the police officer or firefighter at the time of the disability, PSEBA benefits for a family can be $1 million, right? Over the course of an employee's life and their spouse and their kids, that can be very, very costly. So we work closely with our members in these cases to make sure that if the village needs to intervene because there's a dispute or an IME that should be introduced at the pension board, that's the way that we make sure that the pension board is fully apprised before they make their decision. But we also know that the long line of cases in Illinois for many years now have said that the first prong of PSEBA is answered by the pension decision. So it's only the second prong then that potentially could result in not giving PSEBA benefits to an employee who ends up with a disability pension. So in trying to control for the costs that PSEBA impose on municipalities, this appellate court case affirms the holding, which has also been rendered in other opinions, that you can decide which health plan is available for any PSEBA beneficiaries, right? So in this case, the city of Peoria had identified its high deductible health plan as the plan that PSEBA beneficiaries would be eligible for. And this particular plaintiff wanted the low deductible health plan. And so Peoria, in response, said, that's fine, we'll put you on the low deductible health plan, but you have to pay the difference in the premium between the low deductible and the high deductible, because we have identified the high deductible plan as the basic plan for purposes of PSEBA recipients. And the Illinois Appellate Court said, yeah, Peoria can do that. So I would encourage all of you to, hopefully you already have a local hearing process, right, for PSEBA applicants. And so when you get after the disability pension, then you have a hearing on section 10B to see if it was an emergency response and all that stuff. Well, in that same document where you create that hearing process, you should reference that the health plan that's basic is your lower cost, whether it's an HMO or a high deductible plan. And so Lisa, I see there's a question.
Yes, going back to the last slide, if our municipality has a collective bargaining agreement with discipline removal language that is not valid due to this court decision, and should we not honor requests for discipline removal?
Yeah, so I think you need to talk to your labor attorney about what you need to do right now, but you should not be destroying the disciplinary records for right now. And you should probably put the union on notice that this case was decided by the Illinois Supreme Court, and invite them to bargain. You can't bargain over whether to destroy the records. You can bargain over perhaps a process, but you can't destroy the disciplinary records. And I am interested in what the labor attorneys, I haven't talked to any of them about what they're doing about this. I always hated those provisions because of litigation, quite honestly. So, if one of your officers is sued, it's pretty standard for the plaintiff attorney to ask for their entire personnel record. And if you say, well, we destroy disciplinary records that are more than 2 years old, there's a possibility of an adverse instruction going to a jury, which is, hey, you know what, since they destroyed it, you can infer that there were, in fact, disciplinary records. The union should be sensitive to that. When I worked in Naperville, while we would destroy the records or remove them from the personnel record in HR, we kept the records in legal for purposes of potential litigation, so that we wouldn't end up with that negative inference. But yeah, I think everybody should be talking to their labor attorneys and asking them, all right, what should we be doing? You should be putting your unions on notice that you're stopping this practice right now and that you're willing to discuss the issues with them. But the Illinois Supreme Court has said that you can't do it anymore.
Okay, and we do have another question going to the health plan slide. If you establish a new health plan, high deductible, after a former employee goes on PSEBA, can you move them from a low deductible plan to a high deductible plan?
That's a really good question. I don't know if that's been decided, but I would say this: health plans change maybe every year, right? And so I think it's reasonable to every year when you have design plan, plan design changes or whatever, that you identify your PSEBA plan and that you announce it. I think that you can do that. I don't know that there's a case directly on point on that question yet, but I would say that based on the reasoning of the court here, that you can identify a health plan for PSEBA recipients, that you can change that on an annual basis based on how your plans change. There isn't a grandfather clause in PSEBA, and I don't believe that you could end up, a lot of municipalities have decided we're going to eliminate our PPO and the only PPO is going to be a high deductible plan, right? If a recipient was already on the PPO, do you have to continue that plan because somebody had PSEBA? I don't think so. No, I don't think so at all. So there's some pretty good language in this appellate court case. So I would encourage everyone to identify what plans they want their PSEBA recipients to be on and make it very clear. So we have seen a whole lot of stuff going on with police across the country. And I forgot to just make a quick plug for our webinar next week on civil unrest. And so October 14th, we have an expert talking about how to plan, prepare, and handle potential civil unrest as we get ready for the election coming and the expectation that there could continue to be civil unrest. And then on the 15th, we have a roundtable with IRMA members talking about how they handled various situations over the last few months. But I wanted to just do a little different perspective on what you're seeing in the media. And so I looked up what the 7th Circuit in 2020 has ruled in police deadly force cases. And in all 5 cases that I found in 2020 that involved deadly force cases, every one of them, the 7th Circuit ruled in favor of the police officers and entered summary judgment for the police officers in those cases. Now, of course, these are very, very fact-intensive cases. And so, every case has to be really studied on its facts. But all of these cases acknowledge the fact that police officers can use deadly force without violating the 4th Amendment. So a couple of quotes here. When an officer believes that a suspect's actions place him, his partner, or those in the immediate vicinity in imminent danger of death or serious bodily injury, the officer can reasonably exercise the use of deadly force. And then the next quote is also important. If the suspect threatens the officer with a weapon, so it doesn't say with a gun, it's just a weapon, deadly force may be used, and police officers may resort to deadly force even if a less deadly alternative is available to the officers. So oftentimes, those of us who like to, quarterback, hindsight's 2020, when we get these cases in, when there's a shooting, we say, wow, that officer had a taser, or the officers had the canine dog with them. Why didn't they just release the dog, or why didn't they use the tasers? The cases say that, you know what, even if they have less deadly alternatives, if deadly force is reasonable, then that's not a reason to question the deadly force. So the Seventh Circuit has rendered several opinions favoring police officers and granting summary judgment to police officers in 2020. Although if you look at the press, you know, you would think that it's different, and we know that there's a lot of police reforms that are being discussed, and we fully expect that the police reforms will be put into place. And our police chief steering committee is closely watching those reforms, and IRMA is working with our police chief steering committee to talk about those reforms. But this is just a glimpse of the case law here for those police chiefs that are joining us for this discussion. You know, the United States Supreme Court issued, I think, 63 decisions during this past term. They just started their new term yesterday. But there were not a lot of Supreme Court opinions that, you know, were really directly relevant for IRMA members. The one that I am talking about here is a case that actually consolidated 3 different cases in 3 different circuits, where a homosexual guy was fired, a transgender, and 2 transgender folks were fired. And while the opinion, it was a 6-3 opinion, and the majority was written by Justice Gorsuch, who is Trump's appointee. He wrote the majority opinion finding that sex discrimination in Title VII includes discrimination based on homosexuality and transgender status. And so there's about, let's see, between 3 opinions. So there's the majority of the opinion, and then Alito wrote a dissent that Thomas joined, and then Kavanaugh wrote a dissent. It's probably 130 pages of all of this. So obviously this was a very difficult issue for the court, but the majority opinion, you know, I was hoping to get a good quote out of it, and that it was just really, really a very, very boring, it was a boring opinion, but I got through it. And so bottom line is that, and I think this has been true based on Illinois state law for a while, but just keep in mind, you cannot discriminate against people because of their homosexuality or because of their transgender status. U.S. Supreme Court says so, and they say what the law of the land is. As far as statutory changes, I decided for this presentation to not talk about any COVID type of issues. Figured we could all use a break from COVID. So I'm not talking about the workers' comp COVID law, or the changes to the Open Meeting Act, or the governor's emergency order. We've had lots and lots of discussions, lots of communication on that. And so I decided not to go through that. And one other thing I just want to mention is that I also did not cover some cases that have come down in the last year related to land use and zoning. We have a special zoning webinar next Thursday, so I didn't want to steal any of their thunder, where we're going to have 3 experts talk about changes in land use regulations, starting with the U.S. Supreme Court's decision in Nick, which basically opens the floodgates to federal litigation about land use decisions. But stay tuned for that next Thursday. Make sure you register for that one. So the salary history law, the Salary History Public Act 101-0177, amended the Equal Pay Act, and it prohibits employers from asking about salary history. So I am hoping that everybody has already gone through all of their applications for employment and deleted any questions about prior salary history. You know, it's kind of interesting because this really doesn't have a big impact on IRMA members, because municipal employees' salaries are already public. But if you're hiring somebody from the private industry and you want to know how much they're making, and so that you don't pay them too much, right? So you can't ask anymore. You can't ask about their salary history. So basically, the way you have to think about this now is, here's what the job is worth. Here's the range that we have. And then you make an offer based on your applicant's experience, not based on what they're currently earning. And so make sure that you've gone through all of your applications and you've deleted any questions about salary history. You also can't prohibit employees from discussing wages and benefits. So that's something that they can talk about. Now, if an applicant, when you make them an offer, if the applicant says, wait a minute, I'm already making whatever, this much money, you're not even giving me a raise, they can voluntarily give you that information, but you cannot solicit it. And if you do, the plaintiff can actually sue and recover damages and attorney's fees. So stay away from questions about salary history, either during interviews or on any application documents that you ask for. Everybody already knows, I'm hoping, about the Workplace Transparency Act. So this is the new mandate to provide annual sex harassment training. The Illinois Department of Human Rights already has a training on their website available. So because these are going to be annual things, I think that it would be good to have somebody at each of your municipalities that can provide this training. You basically have to provide the, what is the definition of harassment, and what do you do if you see harassment, give examples of harassment. Of course, Susan Garvey, our legal director, has many times provided in-person training to our members. We also have a couple of preferred vendors on our website that have that are available to provide that kind of training. And if you ever have any questions, we're available to assist. But with that, I did get through this a little quicker than I was supposed to. Anybody want to complain about that? I don't see any questions. I'm kind of thinking maybe there will be some questions.
Okay, so once again, if anybody has any questions regarding the content that Margot went over, or just any questions in general related to legal updates, you can use the question and answer feature that's located at the bottom of your screen, as well as the chat. We'll leave this open for a few more moments in case anybody wants to enter anything.
But otherwise, I'm really excited about this year's Education Summit. Looking forward to seeing everybody, hearing everybody participate. Over the last couple months, we have had around 25 webinars with around 12 to 1,300 participants. So, we know that you guys are participating in our webinars and enjoying them. We've gotten a lot of good survey responses.
And I will say the one comment we got was it was a very nice presentation and no complaints about being concise and finishing a bit early.
All right, who said that? I just want to know who I can thank.
That would be Patrick Brennan.
Like it. Hey, Patrick, glad you're there. All right, very good. Well, thanks, everyone. We will see you on Thursday for our internal investigation webinar, and hope you all have a really good week.
Thank you very much for everybody attending, and don't forget to complete your survey as you exit the webinar. Have a great day.